I'd like to welcome you to the American Constitution Society's annual Supreme Court preview. I'm Caroline Fredrickson. I'm the president of ACS. ACS was founded in 2001. It's a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues, such as the ones we'll discuss here today. As if the Supreme Court's October 2011 term was not enough to demonstrate the importance the courts have on all our lives, the 2012-2013 term may just rival it in high-stakes cases. Issues to be determined by the court this term include the constitutionality of the University of Texas's consideration of race, among other factors, in its admissions program, whether corporations can be held accountable in U.S. courts for human rights violations committed overseas. And lurking on the docket, should the court grant review, are cases concerning the constitutionality of the Defense of Marriage Act, California's Proposition 8, and Section 5 of the Voting Rights Act. To lead us through the discussion today with our very distinguished panel, we have a dear friend to ACS and renowned constitutional scholar, Adam Winkler. Adam is a professor of law at UCLA School of Law. His work has been cited and quoted in landmark Supreme Court cases, including opinions dealing with the Second Amendment and with corporate political speech rights. And I commend to you his book, Gunfight, The Battle Over the Right to Bear Arms in America. His commentary has been featured on CNN, in the New York Times, the Wall Street Journal, and numerous other outlets. He is a contributor to the Daily Beast and the Huffington Post. And prior to entering academia, Adam was in private practice defending, among others, Michael Jackson and O.J. Simpson. So by comparison, examining the Supreme Court term should be a walk in the park for Adam. So thank you, and please join me in welcoming Adam Winkler.
Thank you. Thank you, Lisa, for that wonderful introduction. Thanks to ACS for organizing this event. Thanks to all of you for coming out and making it a good event, and especially to our panelists, quite a distinguished group indeed. So, last year's term was one of the most important in the Supreme Court's history, and certainly one that will be studied for generations to come. The most watched case was, of course, the healthcare case, in which the Supreme Court narrowly upheld President Barack Obama's landmark healthcare reform law, thanks in large part to a surprising and apparently last-minute change of heart by Chief Justice John Roberts. As I said, the opinions in that case will be studied in constitutional law classes like the one I teach at UCLA for generations to come. Although I guess Chief Justice John Roberts might hope that at least his more conservative brethren forget about it quickly, as evidenced by their apparent anger or disappointment with the Chief Justice in their dissenting opinion and as revealed in the leaks that followed the Supreme Court's term. The court also issued landmark rulings on immigration. For instance, overturning most, though not all, of Arizona's controversial crackdown on undocumented aliens. The court continued its, less surprisingly perhaps, but equally important, continued its effort to fundamentally reorder the political process, not only summarily affirming its Citizens United decision that held that corporations and other entities can spend an unlimited amount of money on influencing elections, but also in an important case dealing with labor unions, articulated new rules that are likely to make it significantly more difficult for labor unions to raise money to spend in electoral politics. The court also had important First Amendment cases, including one in which the court for the very first time held that clearly and unambiguously, objectifiably verifiable false information was protected by the First Amendment. And there were, of course, important criminal law cases, including an important Fourth Amendment case, that turned, remarkably enough, on a debate between the justices over whether the Founding Fathers could have ever imagined a very tiny constable hiding out in a coach to record the movements of the carriage. And, you know, given how important last year's term was, you'd be forgiven for thinking that this term will be a quiet one. You might be forgiven, but you'd be wrong. The Supreme Court has a series of cases on the docket and potentially more cases to come that promise to make this another high-profile landmark year for the United States Supreme Court. Issues ranging from the constitutionality of race-based affirmative action to the continued viability of the Voting Rights Act, inarguably one of the most important pieces of legislation in American history. The court also has on its docket important criminal law cases dealing with the Fourth Amendment and other criminal law issues, cases dealing with access to the courts, and potentially even cases dealing with same-sex marriage, although that will have to wait and see somewhat. I can't think of a more prestigious and expert panel than the one in which I'm honored to join here today to discuss this upcoming term at the Supreme Court. Ilya Shapiro is a senior fellow in constitutional studies at the Cato Institute and the editor of Cato's Supreme Court Review, and the author of numerous amicus briefs every term in the Supreme Court, including the forthcoming one. Elise Boddie is acting director of litigation at the NAACP Legal Defense Fund, where she oversees trial and appellate strategy for the legendary civil rights organization. Kenji Yoshino is the Chief Justice Earl Warren Professor of Constitutional Law at New York University and one of the nation's leading scholars on LGBT rights issues, and the author most recently of wait, I have to look it up because I've forgotten the title, I apologize. 1,000 Times More Fair, What Shakespeare's Plays Teach Us About Justice. To Kenji's left, we have Lisa Blatt, who is an attorney at Arnold and Porter and the head of their appellate and Supreme Court practice. Lisa is also the record holder for the most oral arguments at the Supreme Court by a woman, and we're very happy to have her. And then finally, at the end of our panel, Tom Goldstein of Goldstein and Russell, also frequently seen at the Supreme Court's lectern, and the founder of SCOTUSblog, simply the internet's best resource on today's Supreme Court. So on behalf of the American Constitution Society and myself, I thank each one of you for coming out and joining us for this discussion. I'd like to begin our discussion today with certainly one of the cases that's certain to make headlines this year in the Supreme Court, and that's the Fisher case dealing with affirmative action at the University of Texas. And to tell us about this case and its importance and its implications, I turn it over to Elise Boddie. Thank you.
Thank you, Adam, and thank you to the American Constitution Society for inviting me to join this wonderful panel. So I understand that I have 7 minutes to talk about Fisher, and am I doing Shelby? Mm-hmm. Okay, so and a voting rights case that's lurking possibly on the Supreme Court's docket. So Fisher, as Adam mentioned, is an affirmative action in higher education case. And let me just start first by saying that both Fisher and Shelby County, Alabama versus Holder, which I'll talk about in just a second, are cases that present a core question. And that is, what are the pathways to opportunity and civic engagement going to be like in this country in the future? Will we keep the doors open for racial minorities to participate in the centers and institutions of power, or will the doors close to racial minorities and people of color? Fisher, the question in Fisher is this: did the University of Texas properly consider race in its college admissions process in order to pursue the educational benefits of diversity? There's an important context here, which is that I have to give you a little bit of history in order to situate the case. This is the University of Texas. In 1996, there was a case called Hopwood out of the Fifth Circuit Court of Appeals, which essentially banned the use of race in undergraduate admissions process at the University of Texas. In response, the state of Texas passed a law that is commonly referred to as the top 10% law. That law essentially required UT, as the flagship institution in the state, to admit all students who graduated in the top 10% of their class. Now, the reason for the law was essentially to promote diversity in the undergraduate institution. And the reason why that works is because Texas, as it turns out, is a highly segregated state. And so the state legislators were aware that by requiring the University of Texas to adopt this law, that it would promote diversity in the absence of individualized considerations of race and admissions. Along came the Grutter decision, a Supreme Court decision in 2003, which effectively overturned the Hopwood decision. Grutter was a critically important case. It came out of the University of Michigan. And what Grutter said was that diversity, the pursuit of diversity in order to promote educational benefits, is a compelling interest, that universities may consider it, provided that race is one of many different factors that are considered in the admissions process, provided that the university has explored race-neutral measures that don't consider race in an individualized way, and that it satisfies the other elements of the narrow tailoring inquiry, which those of you may remember from constitutional law is part of the constitutional inquiry that an institution has to satisfy in order to consider race. And Grutter also critically said that a university may consider race in order to create what it described as a critical mass, a meaningful representation of underrepresented racial minorities in order to realize these educational benefits. And the reason behind the pursuit of critical mass is because numbers matter in order to address the persistent racial isolation of students of color at the University of Texas, to alleviate the sense of tokenism that students feel when they feel that they're the only one in the room, and they feel compelled to be representatives and spokespersons for their race. This was the language that the Grutter Court used in its 2003 decision. UT carefully considered the landscape of its student body, determined that in light of the Grutter case, in light of the persistent racial isolation at the undergraduate level, that it would reintroduce race into the process. So essentially, the University of Texas followed the rules. I should also add that LDF, we did file an amicus brief in support of the University of Texas in this case. So as is probably apparent from my remarks, we do have a view about this, that the University of Texas is in the right here. Abigail Fisher, who was not in the top 10% of her class, was denied admission back in 2008, sued the University of Texas on behalf of herself. It was not, this is not a class action. And she essentially alleges that the university did not fully comply with the dictates of Grutter. We clearly believe that's wrong. There was a massive outpouring of support for the university. Over 70 amicus briefs were filed in support of the university during the briefing process, which closed in August. An oral argument will be October 10th. And so the key question in the case, the legal question, is essentially whether the university's consideration of race in the individualized holistic process is constitutional in light of the diversity that was also created by the 10% plan. So that's essentially the legal landscape for Fisher. Shelby County, I have 1 minute. Shelby County, Alabama versus Holder. This is another case that the Legal Defense Fund is in. We represent interveners in Alabama. This actually is a case that the court has not accepted. There was a cert petition that was filed. We think for various reasons that the court should not accept this case, that this is essentially settled law. It involves a facial challenge to Section 5 of the Voting Rights Act, a very important provision. What is Section 5 and why do we have it? In 30 seconds. Essentially, we had 100 years of persistent discrimination by many states, discrimination that prevented African Americans and other people of color from voting. In light of the Reconstruction Amendments, the 14th and 15th Amendments, which essentially empowered Congress to provide measures that would combat this discrimination, Congress in 1965 passed the Voting Rights Act. The key provision of the Voting Rights, one of the two key provisions of the Voting Rights Act was Section 5. Section 5 essentially says that if you are part of one of 16 covered jurisdictions throughout the country, that you need to pre-clear changes to your voting laws. Pre-clearance is achieved either by the getting permission from a 3-judge panel in DC or by the Justice Department. Shelby County, Alabama has filed a facial challenge seeking to declare Section 5 unconstitutional. I'm getting the big red stop sign from the gentleman in the front, so I'll stop there and I'll take questions afterwards.
We will open up the floor to questions a bit, but before we move on to our next cases, Ilya, do you want to offer any commentary on this?
Sure, I filed in both of these cases. In Fisher, I don't want to say anything about the merits foursquare. I think the court will choose to dodge the bullet and not decide to either expand, reaffirm, or strike down Grutter. They'll probably say that, and probably in an opinion by the Chief Justice, because this is the minimalist way to go, that because Texas already is employing a race-neutral manner, the top 10, or actually now it's been changed to the top 8 plan that seems to be working for diversity purposes, there's no need to further take race into account. And so they'll say, yeah, Grutter is still good law, but on the narrowly tailored point, you're already narrowly tailored this other point, and so for the remaining 25% of the class or whatever, you can't do that. That's what I think they'll do. But I should also highlight the brief in support of neither party by Stuart Taylor and Richard Sander, one of Adam's colleagues at the UCLA Law School, about mismatch. That even the consideration of race for admissions is disserving the people that it's even most supposed to serve, the minorities that get in because of how it affects their learning and et cetera, et cetera. The brief is a summary of a larger book that they have coming out called Mismatch, and I commend that to you. It's really good social science. I doubt it'll actually affect the case. It'll either reinforce the justices who are already inclined to vote one way, and the others will likely ignore it. And on the Voting Rights Act cases, you can read my remarks in more depth on Tom's blog, on SCOTUSblog. They have a symposium last week going into this week. But basically, I agree with Justice Thomas in the previous Voting Rights Act case that the Voting Rights Act is really significant, really important. Section 5 has done everything that it has wanted to accomplish. We should declare victory and move on. Although there's and leave Section 2 and the actual Constitution to deal with actual discrete issues of racial discrimination in voting. Although there's, again, a narrowing thing that the court could do, striking down the coverage formula of which jurisdictions are still covered, which is based on 1972 statistics and covers now what seems like a random assortment of places. So they could just strike down that Section 4B, the coverage formula, and say, Congress, if you want to come up with a new one, Section 5 would still then return to operation.
Fact about Fisher. Disclosure, I am a University of Texas undergrad and law school alum. I also filed a brief on behalf of the American Psychological Association. A lot of it was on this mismatch theory, which I don't think was accurately stated. The premise of that is that African Americans should not be at elite schools because they won't do well. So I maybe you want to read that book, but that's the premise. But on UT and the Fisher case, the fun thing about the briefs is guess which justice was quoted 50 times? 50 times. So Justice Kennedy, so the petitioner's brief, the respondent's briefs, and the parties had 20 citations each to Justice Kennedy, and the reply brief had 10 citations to Justice Kennedy. So I don't know what that says. The other thing I will say about affirmative action, because there's all this highfalutin legal talk. But what's going on at bottom is this inherent tension in what the court is saying. On the one hand, it's saying you can't look at race. You have to look at the whole individual, and this kind of holistic thing and full file review, which I don't really understand that. But apparently you're looking at all kinds of whole personness. And on the other hand, the negative is, but it has to work. So if you're looking too much at the whole and you don't get enough of diversity, then your plan is unconstitutional. So both sides are basically talking out of both sides of their mouth. None of this makes sense to me. And the bottom line, what's going on in Texas, and the buzzwords that you'll hear at oral argument are things like racial demographics and classroom diversity. So what Texas is upset about, and for someone who saw almost no African Americans on either campus, is they have a lot of Hispanics, but they don't have enough African Americans. And that's what Texas is upset about. The top 10% is pulling in Hispanics, but not African Americans. And what the other side is saying, Burt Ryan on behalf of Abigail Fisher, is UT just wants to cherry pick the African Americans it wants. And it paints a very negative picture of Texas looking at that it wants to look at elite African Americans. So anyway, look for that kind of stuff at oral argument. I think your prediction may not be that far off, whether they'll overrule Grutter or just overturn or uphold Texas's plan. But a lot of this is involved in the local politics and the racial demographics of Texas.
Mm-hmm. Mm-hmm. Yeah, I want to respond to what Lisa said. I do think that there is a way of threading the needle in between this idea of using race as not dispositive and trying to just use it as a plus factor and giving the individual holistic look on the one hand, and on the other hand, the seemingly contradictory notion of trying to achieve a critical mass. I think what's going on there that would actually unify both parts of that is this idea that you don't want to stereotype people, right, on the basis of race. So on the one hand, you want to engage in holistic review and just use race as a plus factor, rather than using a quota or a set-aside that says this number of seats are just seats that minorities can compete for because you don't want to stereotype people on the basis of race. On the other hand, if you don't achieve a critical mass, as was mentioned earlier, the problem is that individual racial minorities become spokespeople for their race. So I was recently at University of Vermont. They still have the problem there where professors look at the only non-white person in the classroom and say, so what's the black perspective on this? Or what's the Asian perspective on this, right? And so you need that critical mass that is not a quota in order to...
count as minorities, just so you know that.
I do know that, but the logic still would apply, actually. I mean, normatively, yeah, whether or not you... yeah, let's pursue the normative implications of the argument. I think that there is a space there to reconcile those two notions. So when you say both sides are talking out of both sides of their mouth, I would say that both sides are confronting a challenge and that they're competing goods there, but that it isn't incoherent for the University of Texas to say we both want to engage in holistic consideration and we want to have a critical mass because both are bound by this non-stereotyping, non-balkanization perspective. I think the only other thing I'll say is that Grutter itself placed an expiration date on itself, so it was a classic instance of a court sort of seeing the time horizon of its own holding. So Justice O'Connor, in her opinion, said, 25 years. I've always read, she said, in 25 years, I hope that affirmative action won't be necessary. I thought that was a really interesting comment. I read it more like a biblical 40, like she wasn't saying 25 years to the dot, but rather, a generation or so. But I think one of the things that's very striking about Fisher is that it suggests that time horizon may be drastically curtailed to 9 years since Grutter rather than the 25 years that O'Connor was envisioning.
Yeah, just really quickly, I mean, I know there is a lot of legal jargon, but in terms of what's going on, it's really important to understand, the premise of the whole person analysis is that the university looks at every relevant factor in order to determine who should be admitted to its campus. And the idea that the University of Texas would not be permitted to consider race in its admissions process is, in my mind, counterintuitive. This is the university, let's not forget, that until it was forced to admit qualified African Americans to its campus in 1950, excluded them by law. So there's an important history here. And the goal here is to create opportunities on campus for cross-racial interaction in order to help defeat stereotypes, racial stereotypes, and the notion that we should have broad categories of diversity, including diversity within and among these underrepresented groups, to Lisa's point. So when you have conversations on campus, you recognize that there are people from different racial minority backgrounds who have different points of view. And that's actually valuable and matters greatly in a country where we have persistent racial separation across communities, where there are few opportunities for students to attend school together at the elementary and secondary levels. So the colleges and universities here are trying to plug that gap. And I have to say, with respect to, because I know this is, there's been some controversy about the university's consideration of Asian students, the reality is that Asian students are, that the race of Asian students are considered, is considered in the admissions process. Asians are, the number of Asian students has gone up on campus since holistic review was adopted. So it's not, I don't want anyone to suggest that being an Asian student doesn't matter in the admissions process. It does, and that's part of the purpose of whole file review.
Thank you for that. So these days, the Supreme Court's Fourth Amendment search and seizures cases have to tackle the most cutting-edge technology around. This term, however, they're going to review the constitutionality of a much less advanced form of search technology, drug-sniffing dogs. And they're
not bionic dogs or anything.
Not bionic. And to take us through those cases and the other major criminal law cases on the docket, I'll turn it over to Tom Goldstein.
Thanks so much. For my 7 minutes, I have 8 cases, so we'll take a we'll take a break halfway through, and you can go to the bathroom. There are 2 drug-sniffing dog cases. These are going to be among 4 cases this term that deal with the question of when it is that the police have to get a warrant. The Fourth Amendment says that you won't get a warrant except upon probable cause, which the Supreme Court has interpreted to mean that most of the time when there's going to be a search, you have to have a warrant. But it has generally held that a drug-sniffing dog doesn't require a warrant because the dog is really detecting emanations that are publicly available, even though it's very sophisticated about them. But of course, if you go, to the airport and there is a dog that goes through your luggage, but even if you're on the street and a drug dog happens to alert, it's generally understood that is not going to be something the police have to get a warrant to do. The question in the first of the cases, Jardines, is what's the application of that rule when it comes to the home? The Florida Supreme Court thought that a situation in which a drug-sniffing dog went up to your front door was analogous to a case called Kylo that's pretty famous that involved the use of thermal imaging technology where the police would literally look through the walls of your house. And Justice Scalia, in an opinion that surprised some people, wrote for the court saying that because that technology is fairly unusual and not common, it invades your expectation of privacy, and if they're going to use a machine like that, they have to get a warrant. The Florida Supreme Court, as I mentioned, said that the drug-sniffing dog was like the thermal imaging. The flaw in that analogy is that it's crazy in the mind of this Supreme Court, at least, which is very comfortable with the fact that, as someone can look through the window of your house so long as they're not in the curtilage, if they can come up to the door and they hear you beating someone up or they smell marijuana, I don't think the court is very willing to draw a line between the dog and what an individual could smell. And so I think it's very unlikely that the Florida Supreme Court's decision will be upheld. The Jardines case has a sister case called Harris, which is the doggy Mensa case. The question is, what does it take to be a drug-sniffing dog? Do you have to be really qualified? Do you have to be an elite genius dog? Or is it enough that the police think that you're generally qualified to do this? And the Supreme Court will hear both of those cases on Halloween, ironically enough, deciding when it is the police can use drug-sniffing dogs, including at your house. The other Fourth Amendment case that's on the docket is called Bailey. This is an application supposedly of the rule that says when the police come to your house, they can, and have a search warrant to search your home, it's another home case, they can detain the people in the house who are there without a warrant for purposes of officer safety. In this case, the officers were watching the house, saw Bailey leave, drive down, followed him for a mile, arrested him there, brought him back to the house under the rule that says that, well, you're in the house now. The difficulty with this rule is it's pathologically insane. I mean, this just, some of the Fourth Amendment stuff has just arrived at crazy town. Justice Scalia, I think, both with respect to the application of his decision in Kylo to the Jardines drug-sniffing dog case, and also Justice Scalia has actually been one of the leading forces at the court on limiting the kind of wild application of these Fourth Amendment doctrines. There was a recent case called Arizona versus Gant, which famously carved back on a rule that had said that when you're pulled over in your car, you can search the vehicle. The officers can search the vehicle, not just you, not just right where you might be able to reach for a gun or something like that, but say the trunk, on the idea that you need to protect the officers even when you are under arrest in the police car. So what would happen is the cops would pull you over, arrest you, put you in the back of the police car, and then handcuff you, put you in the back of the police car, and under the guise of needing to protect themselves from the weapon you might get from the trunk, would search the car without a warrant. And the Supreme Court put a stop to that, and it's going to, I think, put a stop to this crazy idea that you can watch the person leave the home, arrest them, and then bring them back to the house on the theory that, well, they're in the house now, therefore the rule that says that once you're in the house, I don't have to have an arrest warrant to hold you there. The most interesting...
Cato actually filed a brief with the ACLU in that Summers case. I mean, I think the court probably will not take too long in agreeing with Tom's analysis.
As it should. The most interesting Fourth Amendment case of the term is about new technologies, and that's going to be about DNA. Maryland has a statute that says that if you are arrested in the state can take DNA evidence from you for purposes of matching it against a database to see whether or not you did something bad in the past. And the question is, if you are not convicted but merely arrested, is that a Fourth Amendment search that would require a warrant? The Maryland Court of Appeals, that state's highest court, said yes. The answer is actually no in the Supreme Court, because the justices, I think, are going to conclude that that is just not very much of an intrusion to take the DNA. But it's a very close and interesting case about new technologies. That is the Fourth Amendment case to watch. The Chief Justice issued a stay of the Maryland Court of Appeals decision, which is a strong indication that there's a very good chance that cert will be granted. We are counsel in 2 criminal immigration cases. One of them is important. The one I'm doing is not. The important one is a case called Chaidez. It's about the retroactive applicability of a case called Padilla versus Kentucky. That's the Supreme Court's decision that said if you are going to plead guilty, you have a constitutional right to effective advice about the immigration consequences of that guilty plea. Because lots and lots of times people would plead guilty and then find out later that they pled guilty to something that is a deportable offense. And the Supreme Court recently held that you have a constitutional right to get good advice about that. That's the case called Chaidez. My case is called Moncrief. It's the question of if you are arrested and convicted of possession with intent to distribute marijuana, whether you are automatically deportable or semi-automatically deportable or probably not deportable. And that makes a big difference for a lot of people who are actually convicted of crimes involving simple social sharing of marijuana. The last 2 cases that are already on the docket involve competency. It's settled that you have a constitutional right to be competent at the time of your trial, and in a capital case at the time that you would be executed. That's the so-called forward right. The Supreme Court, in a pair of cases to be argued on the same day this term, will decide whether you have a statutory or constitutional right to be competent at the time of your habeas corpus proceedings, in between the other 2 rights. And that is a potentially important question for a lot of criminal defendants who are mentally ill.
I think we should give him a round of applause for achieving his 7 minutes.
Any commentary on?
No, Tommy, I'm interested. So do you think in the Fourth Amendment cases there'll be any chance for the court to sort of issue any sweeping proclamations about doctrine, or you think that they'll just go down on the facts?
No, I think that these are pretty much baby cases, that the big things like Jones, GPS, the closest that we're going to come to that is the DNA case. That's the most foundational of them, because there are really 2 competing ideals here. One is, how intrusive is the search? Doesn't seem to be that big a deal, but it is fundamentally very private information, your DNA. And so that is probably the biggest picture of Fourth Amendment case.
And to take us through some cases that are going to deeply affect business this term, although not all of those cases, I'm going to turn it over to Ilya Shapiro.
Well, thanks very much for having me. I didn't qualify for the Federalist Society's equivalent of this, but I'm grateful to ACS for including me on this panel. I guess because they needed somebody to take the really boring cases that nobody else wanted to take, and yet that still are important. I actually don't think of my cases as the business ones. Two of them don't even involve businesses on either side. I think of the business ones as the class action cases, the securities cases, and I'm sorry to disappoint all of you who showed up just to hear about the ERISA case. You can talk to me in the hall afterwards. So the first one is Arkansas Game and Fish Commission versus the United States. What a great name, right? And this, the issue here is when a tree falls in the forest due to temporary flooding, does it make a sound for which you can recover under the takings clause? So the Arkansas Game and Fish Commission owns thousands of acres of land surrounding certain rivers in the state of Arkansas and operates wildlife preserves, hunting preserves, valuable timber there, et cetera, et cetera. The Army Corps of Engineers occasionally for their flood control plan and other worthy goals floods the land or takes steps that do certain things. In the last 15 years or so, they've started increasingly flooding the land in unexpected ways, deviating from the normal plans. And these are all temporary floods. They recede eventually, but there's tremendous damage that's caused to this property. So the real issue, after you've decided to determine the metaphysical one I posed at the beginning, is whether government actions that impose recurring flood invasions must continue permanently to take property within the meaning of the takings clause. So there's some weird precedent on this that says temporary takings are compensable and permanent floodings are compensable. But what about temporary floodings? I mean, if Tom talked about some crazy and pathologically crazy theories, I think the government's position here is, I don't know, ludicrously crazy or something like this. I think the Arkansas will win here. I will note that Justice Kagan is recused. And I should note also that Cato filed a brief here as well, which I won't get into, but I do have a perspective on this. The next one is an intellectual property case, which asks another important question. Can you judge a book by its cover's country of origin? Here, John Wiley & Sons, which publishes textbooks, has sued a guy, a PhD now in mathematics, I believe, who is a foreigner. I think he's from Indonesia. And he found that the cost of textbooks was really expensive in this country. I'm sure all of us can sympathize with that. So what he did was ask his friends, parents, relatives to send him textbooks that he bought that they bought back home in Indonesia. And it turns out that textbooks in Indonesia, even the same kind, the same ones, the foreign edition, are a lot cheaper. So he said, well, I can make money off of this, aside from just getting cheaper textbooks. And he ended up selling something like $900,000 worth of these foreign-bought textbooks that he then imported and made about $100,000 of profit on that. And the issue is the confluence of two sections of the Copyright Act. One that prohibits importing a work without the authority of the copyright's owner, and the other that allows the owner of a copy, quote, lawfully made under this title, to sell that without the copyright owner's permission. So he owns this lawfully, of course, but he did import it. So how do you, this is called the first sale doctrine. How do you interpret that in this circumstance? I have no idea how the court's going to rule on this. They're all over the map on intellectual property cases recently. Those of you who are into IP, I think it's the biggest case of the term for that so far. But I don't have a solid prediction because it's a really difficult and kind of textually fine case. And then there's two Clean Water Act cases, the administrative law stuff. One, I actually learned a new word, silviculture. Anyone know what this means? That's right, logging, right. Operating forests and studying forests and operations relating to forestry. And I'm not talking about the lumberjack games that you can see on ESPN late at night or anything, but maybe that is silviculture as well. Anyway, this is Georgia Pacific West versus Northwest Environmental Defense Center, and it's paired with another case that involves the Oregon Department of Forestry. Timber companies take lots of trucks down these state-operated roads to their to get the timber and you know, do that sort of silvicultural activity. But it turns out the trucks on these roads, they ground up rocks and throw up dust, and all of this sediment ends up in streams that the plaintiffs allege hurt salmon by smothering eggs, reducing oxygen levels, interfering with feeding, and burying insects that provide a source of food. So you learn a lot reading about the Supreme Court. The issue is whether the Oregon, the Department of Forestry, and the lumber company needed permits for, quote, point source discharges under the Clean Water Act. And this argument runs up against a long-held EPA position that this sort of activity does not constitute a clean point discharge that you need a permit from the relevant authority to get. It's a so-called silvicultural rule that exempts natural runoff discharges resulting from these sorts of activities. Again, Breyer is recused in this one, and again, I have no idea how this is going to come out. Administrative law was my worst case in law school, so again, I have no idea why they have me. I think this is a hazing ritual for those who haven't appeared too much on these sorts of panels. And finally, I think of this, another Clean Water Act case, as the, you know, they're such dry cases, these Clean Water Act cases. I think of this one as the Terminator case, you know, the movies with Arnold Schwarzenegger, and not just because this originates in California, but when I think of one of the defining kind of memories I have of the Terminator movies, aside from like the guns and the robots and the molten stuff and whatnot, is the big channels, concrete channels in LA that channel the rivers and the streams and, you know, runoff, and some of these are like open sewer systems and things like this. And it turns out there's a special name for it called Municipal Separate Storm Sewer System, the MS4. I think that's also the name of a Salvadoran street gang in LA or something. Maybe that's related. I don't know. But the issue is there's stuff that gets into these channels all over the place that isn't emitted by any particular, you know, pollution plant or what have you, but the water quality that then eventually goes into navigable rivers has elevated thresholds, has exceeded the lawful thresholds for various kinds of pollutants, cyanide, copper, aluminum. Sounds like the mining, or maybe not silviculture, but certain type of mining might be, you should get these minerals out. And the issue is when water flows from one portion of a river that's navigable through a concrete channel or other engineered improvement, that's the Terminator stuff, in the river constructed for flood control, into the lower portion of the same river, whether there can be a, quote, discharge from an outfall under the Clean Water Act, notwithstanding certain precedent that the transfer of water within a single body of water can't constitute a discharge for Clean Water Act purposes. I'll read the opinion on this. I probably won't understand it either, but those of you interested in Clean Water Act stuff, I think this is important in terms of how urban waste management systems are going to be run in the future.
Any comment before we move on to our next? Just want to give them the opportunity. In recent years, the court has imposed new restrictions on access to the courts in the class action context and elsewhere. Lisa Blatt, we've asked to discuss the cases on the docket that concern access to the court more broadly and some other issues. Thank you.
Yeah, I actually thought I was covering the business cases, so I had just an overview. This is a robust business docket, unlike last term. So it's a meat and potatoes kind of business term that will get a lot of cases will be decided that are important to businesses. Class actions feature quite dominantly. There are 4 class action cases already, and there's only 40-something cases, maybe 42 cases on the docket. 2 of them are the fallout from Walmart, and Adam, you just said access to courts. I think about it as curbing abuses. What is happening is the Supreme Court, just like punitive damages from a few years ago and the Twombly-Iqbal pleading standard, but I would say probably a decade of silence or maybe 2 decades of silence on class actions. And yet businesses have been educating the courts about how the whole war is either won or lost at the certification stage, because once a class is certified, very few businesses can afford to risk what might be ruinous liability by actually trying a class case. You don't see those. So everything now is turning on certification. And the question is Walmart just limited to the employment context? And two cases involve that. One is Comcast, which is an antitrust case. And the question there is, it's a question of, can you have damages on a class-wide basis? And the plaintiffs are saying, we'll get to the experts and how we're going to prove damages at the merit stage, just certify the class. And Comcast is basically saying, represented by the counsel at Walmart, for Walmart rather, Gibson Dunn, is saying, no, you've got to run through a Daubert type analysis. You have to make sure the expert testimony is sufficiently reliable under Daubert, and you have to decide that at the certification stage before you certify the class. The same question comes up, or similar question, in the Amgen case, a securities fraud case. And the question is whether the materiality of the misrepresentation should be decided at the certification stage as opposed to the merit stage. The other two class action cases are more, I'd say, on a constitutional level, but potentially could be very significant. One of them involves, it's funny after watching this for a long time. I mean, all defendants and businesses want to get their cases in federal court, which is such a huge change from, say, 20, 30 years ago. But Congress passed the Class Action Fairness Act that allows removal of big class actions. And the trigger is if it's over 5 million or it's over 100 plaintiffs. So guess what plaintiff lawyers do? They file a bunch of cases with 99 plaintiffs, or they file a case with a stipulation saying, I'm not going to seek over 4.99999 million. And so the 4.99 million is the case the court granted in Knowles versus, I think it's, or Stanford Insurance Company versus Knowles. And the question is that stipulation that you're not going to seek more than $5 million, can that bind absent class members who haven't even joined the class or had their identity claimed? And there's another, again, similar case involving the Fair Labor Standards Act. And here's a case where an employee didn't get, whether it's overtime or not, his pay wasn't calculated correctly. He brought a collective action. It's not a class action, but it's a collective action very similar to a class action. And the company made him whole, offered him all damages that he could get under law. And the question is, does that moot the case? The defendant immediately moved to dismiss, saying, your case is over now, you've been paid off. And he says, no, there's all these other people I would have liked to have brought suit. And so the question is can companies moot the case by paying all the amount? The other case, which is of, I don't know, I'd say a pretty huge significance, the Kiabel case involving the Alien Tort Statute. It's also interesting because it was actually argued last term on the question of whether corporations can be liable under the Alien Tort Statute. Alien Tort Statute passed in 1789. It's one sentence. It says that aliens can bring tort actions in district court for violations of the law of nations. I don't have any clue what that means, and I don't think anyone else does. But if corporations can't be liable, the statute doesn't do much work. For what's happened in the last 20 years is basically plaintiffs abroad have tried to make our court system of universal jurisdiction and tried to get remedies for human rights abuses occurring abroad. This case takes that to the extreme because it's a bunch of Nigerian plaintiffs suing two foreign corporations for allegedly aiding and abetting the Nigerian government in human rights violations overseas. And this is a pretty typical fact pattern. The aiding and abetting is either supplying cars or weapons or food to soldiers or either giving your land to the military or something like that. So there was oral argument last term, and Justice Alito asked during the argument, he reads the complaint and says, oh, we've got foreign plaintiffs, foreign conduct, foreign defendants, and he says, what is it to the petitioner's lawyer, what is a case like this doing in the United States? And the chief kind of, added on to that, and then they issued an order, which will be an ordered briefing, and this case will be argued the first day of the term, October 1st, saying, does this statute apply when the acts occur outside the sovereignty of the United States? A lot of briefs, I think 50 amicus briefs were filed on this. I don't know how the court is going to come out. The one thing that's interesting about this case is this is a case where I would say the liberal justices care about what foreign governments think of the court. And this is a case that is appealing to sort of what should be the role of United States courts in dealing with just rectifying human rights abuses that have no connection whatsoever to the United States. Oh, and I definitely filed a brief. I have a disclosure on behalf of a bunch of U.S. corporations.
Saying.
And I understand that the class actions that you described arise in the business context. I do want to push back on the notion that class actions are, abusive. They're a very important tool in civil rights litigation. Many times you're dealing with plaintiffs' counsel that have to struggle with asymmetries of information, and to the extent that it's harder to certify a class, that makes it much more difficult to litigate some of these cases. So I understand that's, you're talking about a different context, but class actions initially were a very important way for civil rights plaintiffs to ensure to pursue broader systemic relief.
Yeah, and when I say excesses, you see this in preemption too. I mean, what's going to happen, I think, with class actions too, is the court will keep cutting back on and curbing abuses until corporations start abusing it, and they will cut back, and it's going to have to be a civil rights case. It's going to be very hard for the court to turn away a class action on race. But what you're seeing are things like antitrust and securities, and it's coming up in a very unattractive vehicle for the plaintiffs, especially in the Walmart case. I don't think there's probably a liberal justice alive who's happy with that plaintiff's lawyer who brought a case on behalf of 1 million people. He did not do the civil rights community any favor by bringing that case.
I want to say just briefly on Kiobel, because I filed briefs both on the corporate liability issue and on the extraterritoriality issue. I don't think the court wants to reach the corporate liability issue, and they now have this opportunity just to say that there is no universal jurisdiction, at least not under the current statute. That's probably how they'll decide it. But it was fascinating working on this case because it's not just international law, and I really enjoy working at the intersection of international and constitutional law. But you go back and you're actually reading Grotius and Vattel and what does the law of nations, which a term that actually appears in the Constitution, what did that mean in 1789, and how does this relate to piracy and all these different things? And I think you'll see that come out in the arguments as well. Now, I think that corporations should be liable when they're committing, bad things and things like that. This statute, I don't think, makes them liable because the modern corporation was not contemplated in 1789. So I think Congress should, regardless of the outcome of this case, Congress should go back and amend the Alien Tort Statute and modernize it. Again, this is not a constitutional issue. It's a statutory one.
And then last but not least, I'd like to turn to Kenji Yoshino to talk about some cases that the Supreme Court hasn't yet agreed to hear, but most experts think that they will at least wade into the same-sex marriage issue some way or another this term.
Great. So it's a real pleasure and honor to be here. I want to think about these cases as existing in two buckets. So one bucket is the DOMA cases, and these are federal challenges to a federal definition of marriage. And then the other bucket consists of federal challenges to state definitions of marriage. So I want to think first about what these two buckets have in common and then take each of them separately. So think about this as a talk in 3 parts and 7 minutes. So first, let's think about what they have in common. I mean, one thing that they have in common is a genesis. So what all of these statutes the reason that all these statutes were called into being was that in 1993, the Hawaii State Supreme Court intimated that it was going to permit same-sex couples to marry in that state. And this set off a kind of seismic backlash or reaction, both by the federal government and among the several states. So in 1996, the Congress passes the Defense of Marriage Act. And the Defense of Marriage Act says several things, but the pertinent provision says that for all federal purposes, the definition of marriage will be a union of one man and one woman. So the word marriage occurs 1,138 times in the US Code. And this is a highly significant definition. And what's being done in the DOMA cases is equal protection challenge to that, and more on that in a little bit. What the states do in reaction to the Hawaii ruling. By the way, the Hawaii ruling ultimately gets superseded by a constitutional amendment. So the fear of same-sex marriage in Hawaii never materializes, but it's enough to trigger a lot of states to enact mini DOMAs. And what these state provisions do is to define marriage between one man and one woman, thereby effectively operating as restrictions or bans on same-sex marriage. 32 of these states have done this according to direct democracy initiatives. And what this means is that this is not done by the legislature, but rather is done by a plebiscite, a vote of the people. Every time this has come up for a direct democracy, up or down, the definition of marriage has, the traditional definition of marriage has prevailed. The Perry case, which is a Prop 8 case, has to do with a amendment to the California state constitution that's being challenged on federal grounds. But we can think of all of this as being a response to that incident in Hawaii. Two other things that all these cases have in common. One is the standard of review question that is going to be applied to all of these cases. And then the other one is that some of the rationales that the government has produced overlap with each other. So with respect to the level of review, as many of you know, under the Equal Protection Clause, there are various levels of scrutiny. And for purposes of simplicity, let's think about this as heightened scrutiny and rational basis review. There are 5 classifications that the Supreme Court has said receive heightened scrutiny, which is an elevated form of scrutiny. That means that the statute is more likely to be struck down. Those 5 classifications are race, national origin, alienage, although that's a bit of a sport. We can talk about that if you want, gender, and non-marital parentage. So the $64,000 question, or one of them in these cases, is whether or not sexual orientation will be added as a 6th heightened scrutiny classification alongside those other classifications. In determining whether or not a classification gets heightened scrutiny, the Supreme Court has traditionally looked at 4 factors: the history of discrimination, whether or not the trait that defines a group has some bearing on that group's capacity to contribute to society, whether or not the group is politically powerless, and whether or not the group is marked by an obvious distinguishing or immutable characteristic. So the Supreme Court in both of these cases may have to consider these questions, or it may dodge the question as it has done in prior cases, such as the Romer case in 1996, and to say we don't even need to reach that question, which ordinarily you would think of the standard of review as a threshold question, but we don't need to reach that question because even under the most minimal rational basis review, the government has not produced a sufficient rationale. Which brings us to the rationales that the government could give for restrictions on same-sex marriage, either at the federal level or at the state level. And some of these are different, but some of these overlap. So the primary justifications are opposite-sex couples create the optimal environment for child rearing. Another one is that the inclusion of same-sex couples into the institution of marriage would deinstitutionalize marriage and would lower the kind of brand, so to speak, of marriage, so that less individuals would enter into these unions, or the divorce rate would go higher. Another one is to prevent reckless procreation among heterosexual couples. So the idea is that if you, I kid you not here, so this is I call this the gays are too good for marriage idea, because the idea is that because gays cannot procreate internal to their own unions, if you want to have a kid, you have to think really, really hard about it. Gay couples do not have kids by accident, whereas straight couples can have children by dint of casual and temporary sexual encounters. This is what the New York, my own jurisdiction, state Supreme Court said in upholding the restriction on same-sex marriage. And so therefore, same-sex couples have to be kept out of the institution because they don't need the institution as much as heterosexual couples need. So what I'm giving you the rationales in descending order of plausibility here, but so I'll just stop there.
I mean, justification was just it was traditional.
Well, tradition is a hard one, and as you go up the litigation ladder, you see that fall away, because there's a case called Williams that has to do with whether or not you can, it has to do with debtors' prisons, and there's a kind of money line in there that says that tradition alone cannot be a ground for a constitutional violation. And so that's being taken off the table more and more. And it's actually a great point, because tradition is a meme that is often touted in the popular sphere, but once you get outside of political discourse and into constitutional discourse, that rationale falls away.
LDF actually, oh, sorry.
Yeah, if I could just close, finish out the thought with respect to these two cases. I mean, there are some really important differences between the DOMA cases and the Perry case. So as Adam said, it's important to note that the Supreme Court has not granted review in any of these cases, but it has set them for conference next Monday. And it's, I think, more likely than not that it will take the Defense of Marriage Act cases, just because there are so many of them percolating throughout the system, and both sides.
But not then.
That.
Not next Monday, though.
Right. Well, it's actually set Windsor for consideration.
I promise.
Week. So what has happened between?
You talked to General Souter this morning.
Right.
Because the other DOMA cases are not ready, it's going to be just a little while before they're ready to go.
Okay, we should let's talk about this, because I generally would defer to Tom on this, but my understanding was that because the Second Circuit. All right. Well, we'll talk about it. My point was actually that the Second Circuit is thinking about oral arguments on one of the DOMA cases, the Windsor case, later on next week, and so the thought was that the Supreme Court would have to or would want to kind of preempt that discussion, but we can talk about this afterwards. The larger point here is that sooner or late, the expectation is that the Supreme Court will grant review in the Defense of Marriage Act cases. I think that there's a real question as to whether or not it will grant review in the Perry case. So I would call it at 50-50 at this point. It may deny cert and let the Ninth Circuit opinion below stand. So let me just talk about those two cases separately, because they do raise separate issues. So on the, I'm getting the stop sign, but I'm going to take back the time that I used with Lisa, if I may. So one thought, and with Tom, one thought on the on the DOMA cases is that there's a federalism issue that arises. So I want you to think about these cases as really different, right? Insofar as the DOMA cases are different insofar as pro-plaintiff result in the DOMA cases would not require any state to change its definition of marriage. So if you strike down DOMA, all that does is to return us to the status quo ante, which is a very long tradition of the federal government subscribing to whatever the state definition of marriage is. So marriage, as we know from cases like Lopez and Morrison, is a traditional state domain. And as we know from cases like Lopez and Morrison, traditional state domains are domains into which the federal government should be very loath to intrude, right? And so historically, say if a state said, we allow marriage between first cousins, and another state said we don't allow marriage between first cousins, the federal government would follow whatever the definition that the state embraced as its own definition of marriage. So the DOMA case in 1996 actually broke from that tradition of federalism. And so the First Circuit, which is the only appellate court to have disposed of this issue thus far, in the Gill case, said, look, this is a rights issue stacked up with a federalism issue. So it kind of used a pincers movement on the court. It said, look, on the one hand, if you liberals on the court, you should like this case because it's an equal protection case, right? But you conservatives on the court who are for states' rights should like this as a states' rights case because this is a federal intrusion into a traditional state domain, right? So the idea is, this is a kind of Justice Kennedy's most favorite things case, right? Because you're stacking up, gay rights with federalism concerns. So you have the Justice Kennedy of Romer, hopefully stacked up with the Justice Kennedy of the federalism cases like Lopez and Morrison and its sequels, Affordable Care Act being the most recent one. Perry is a very different case because Perry potentially, although I don't think the court is going to do this, Perry potentially has the ability to have the court render a decision that says all 50 states have to flip with respect to their marriage law and that this is constitutionally required. Currently, there are only 6 states that permit same-sex marriage plus the District of Columbia, so it would be flipping actually 44 states, but it would be setting a constitutional floor below which none of those states could fall, and thereby saying no state can permit opposite-sex couples to marry, but not same-sex couples to marry. This comes out of the Ninth Circuit. So what happened in Prop 8 was factually really significant because the court could rule in this case that would limit it to its facts. So what happened in California was that on May 15th, 2008, the California Supreme Court said that there was a right under the California state constitution for same-sex couples to marry. In the subsequent election in November of 2008, Proposition 8 passed. And so the same election that ushered Barack Obama into power also took away from Californians this right of to marry. So one cartoonist has parodied this as a kind of yes, you can, but also no, you can't moment for same-sex marriage. So the reason I go into this is that the district court opinion ruled, I think in August of 2010, on very, very broad grounds, saying there's a fundamental right to marry, and then there's an equal protection violation here. And if the court were to adopt that, that would have to lead to a 50-state solution, right? But on appeal, Judge Reinhart, not generally known for his parsimony, right, writes, in Wolf's terminology, with the pen of Austin rather than a Bronte, right? So you had this crazy, really broad opinion by the district court, and then Reinhart's panel really limits it. So Reinhart and Hawkins, for a 2-to-1 majority, Judge Randy Smith was in the dissent, says there's a much narrower theory in which we can decide this case that would limit it effectively to California. And that theory is you can't give a right and then take that right away on the basis of animus. So there are 3 requirements, right? You can't give the right and then take it away on the basis of animus. And the only state that meets those predicates is California, because in other states, the right never hit the ground. So Maine gave the right and took away the right, but there was never a moment when same-sex couples could marry in Maine, right? So if the Supreme Court adopts that theory, it potentially has the capacity to cabin the holding to California alone. This, of course, would restrict future states from granting the right and then taking it away on the basis of animus, right? But the only state that would currently be affected is California, and that would allow the discussion to percolate through.
The state has to have had a governor who has appeared in the Terminator movies.
Well, that
was a footnote, I think.
Right, yeah. So I take that as a friendly amendment because the case was originally captioned Perry versus Schwarzenegger because Governor Schwarzenegger was the defendant, and he had this classic quote where he said at one point, he had to say this on the fly, and we all say things that we wish that we could have retracted. But at one point he did say that I believe that same-sex marriage should be between a man and a woman. I'm done that now.
I just want to say that LDF filed an amicus brief in the DOMA case in Windsor, arguing that heightened scrutiny should apply, and that if you look at sort of the core equal protection cases, the race cases from the early 1900s through Brown and so forth, that really at the core of the equal protection principle is an anti-subordination principle, and that DOMA, by denying marital benefits to same-sex couples who have been married under state law, essentially are oppressing those couples on the basis of sexual orientation. So.
Yeah, and one of the DOMA lawyers actually reported a heartbreaking conversation. This is Robbie Kaplan with a colleague of yours, where she said that your colleague said, be careful what you wish for, because if you get heightened scrutiny, that will work against you when it gets to affirmative action.
I was that colleague, actually.
Oh, well, there you go. And Robbie Kaplan's response is my response, which is, we'll cross that bridge when we get to it. Yeah, when there's affirmative action for gay people.
I mean, the one little just drama is the administration obviously changed course. In the beginning, this was the Obama administration said that gay marriage was analogous to incest, and now they are obviously going to walk away from that. But look for the other side to be quoting the Obama administration's words back at them. Paul Clement of Healthcare and other fame is representing the members of Congress to support the law. And look for him to say that the president's recent support for gay marriage undermines the claim of gays to claim some sort of minority or suspect status, because it shows that they actually have a lot of political power since the president's now supporting them.
Right, and in fact, I mean, what's interesting about that, so thank you, Lisa, is that, so what Lisa's referring to is that I think on February 23rd, 2011, the government, the DOJ, said that it was no longer going to defend DOMA in court, even though it would continue to enforce it. And so it fell to the bipartisan legal advisory group to do that work. One of the things that is important about that letter that Eric Holder wrote was that he went through his own heightened scrutiny analysis and said that gays met all the requirements for heightened scrutiny. He actually has a kind of preemptive answer to Clement here, and when he was dealing with political powerlessness, because that's really the problematic one of the 4 factors, right? I don't think that as many people are troubled by, I don't think anyone is gainsaying that gays have suffered a history of discrimination. I think most people think of sexual orientation as basically immutable. I think most people think of gays as being just as able as straights to contribute to society. I think the real sticking point is going to be whether or not gays have sufficient political power that gay individuals can avail themselves of the political process and therefore don't need to have the special solicitude of the courts. The memorandum that Holder wrote in response to that raised the point that political powerlessness is actually a term of art in constitutional law. So this is not some random sociologist or one particular lawyer's view of whether or not gays are politically powerless or not. You have to actually look at the comparable groups that have been deemed to be politically powerless. So if you look at the groups that have been granted heightened scrutiny, women were granted heightened scrutiny in 1976 formally. Before that, there's a discussion about whether or not women are politically powerless in the 1973 case called Frontiero, and there's a big fracas in between Justice Brennan for the plurality and Justice Powell and concurring over whether or not women have sufficient political power. But ultimately, if women are deemed to be politically powerless because they don't have representation in the nation's decision-making councils, which is Brennan's line, if women are politically powerless in 1973 or 1976, if we think about where women were then, you have Title VII protecting them, you have the Equal Pay Act, you have a constitutional amendment in the form of the Equal Rights Act that has been voted out of Congress and that the states are voting on. Ultimately, that doesn't go through. But if you think about the amount of political power that's needed in order to pass a constitutional amendment that gives you equal rights, certainly gays are nowhere near that. And I would also add to that, Marco Klarman's point that you actually have to have a heck of a lot of political power before you are deemed to be politically powerless by the courts. So there's a kind of paradox of political power that's operative here. The truly politically powerless and disenfranchised in our society are not even on the court's radar, right? Because they're not even recognized as groups yet that would demand any kind of solicitude from the court. So we're really talking about a sweet spot where you have enough political power so that the court will recognize you, but not so much political power that you can get so many legislative outcomes in your favor that the court feels like it needn't and shouldn't intervene.
Thank you. It'll be a certain equal protection irony if the Supreme Court this year says that gays and lesbians are so politically powerful that they don't need strict scrutiny or a heightened form of scrutiny for equal protection violations, but yet white people like Abigail Fisher are so politically powerless that they deserve strict scrutiny to challenge University of Texas's affirmative action program. I think by the tradition of the National Press Center, we'll open the questions first to members of the press and journalists. So I want to open up the floor now. Yes? Please wait for the mic. Thank you.
I'm Mike McGough from the LA Times. There was an interesting amicus brief filed by Doug Kendall on making an originalist argument for affirmative action, at least as it regards race. And I was just wondering if anybody feels that in the Fisher case there's any appetite on the part of more liberal justices to sort of turn the clock back beyond Boddie and beyond the whole diversity rationale, which is getting very Byzantine and complicated, because originally the diversity rationale was we will have people from different groups who will have different views. Now it's we need a critical mass of different people so that we see that they have different views amongst themselves, and it's becoming increasingly complicated. Is there any sort of sentiment on the court to say we took a wrong turn in Boddie, and what this really is about is compensating a historically discriminated against group, and that's a constitutional value, and we ought to go back to basics and sort of forget about diversity?
It's a really interesting question about which I'm sure folks on this panel would have a very spirited debate. I mean, our view is that Boddie was a loss. It was wrongly decided that that colleges and universities should be able to consider race given the sort of the long history of discrimination in this country. I don't think that the sort of so-called liberal wing of the Supreme Court, it's likely that they will return to that if they ever were firmly there. And that's, it says something about the composition of the court. I do also think, though, notwithstanding everything that I just said, that there is some power to the diversity principle, that is that it makes us better as a country and that it inures to the benefit of everyone. And that really does resonate with me, notwithstanding that I think there is a compensatory rationale that could be legitimately set forth, particularly by the University of Texas, going back to my original point. But I don't see the court going to that place.
Can I respond to that?
So it's a great question. The two rationales that the court has looked at are remediation and diversity. And we see the court listing towards diversity and away from remediation, primarily because of what Lonnie Guinier up at Harvard has said, is it's more attractive to think about racial minorities as individuals who are bearing gifts rather than grievances, and the diversity rationale lines up with gifts, whereas the remediation rationale lines up with grievances. I'm with you, or with the thrust underneath your question, which is to say I think this has been about remediation all along. And I think that when the court talks about diversity, there's always a subtext of remediation under it. If you look at O'Connor's opinion in Grutter, she says, all kinds of diversity are important. When she's asked why is racial diversity important, she says, because there's a diversity of diversities, right? You could say, we care about a ton of other kinds of diversity, but clearly we're lofting up racial diversity as one important form of diversity. And she says it's because of the unfortunate history of race in this country, which to me is just remediation. So diversity can operate as a kind of Trojan horse for remediation, so why not call a spade and say that's what we're doing? I think the reason that we're not is in part because diversity has alternative benefits that accrue to it, but also because the Supreme Court has been really clear in the parents involved case that the remediation rationale has been very, very narrowly cabined. And the kind of remediation that a state is permitted to engage in is to remedy the continuing effects of past discrimination that were promulgated by the entity itself. So it's the entity that's promulgating the affirmative action program that has to look back at its own bad acts that continue on into the present with respect to the discriminatory effects. And that's the only remediation that it can engage in. This broad societal remediation is not something that the court is going to permit on the grounds that it's social engineering.
I agree with that description. I mean, I wish the debate were about competing originalism. I love talking to the folks at the Constitutional Accountability Center and Adam, who joins a lot of their briefs, and because that's actually taking the Constitution seriously. And I agree that diversity is sort of a pretext for some of these other things that justifications that haven't flown at the court. But at this point, I think the Democratic-appointed members of the court are all in, as it were, on the diversity side. So to the extent that that brief gets some hay or gets cited, it would only be in rebutting some originalist points, perhaps, that would be made by someone on the other side.
By the way, I don't think it's a partisan issue because there have been Republican justices who have embraced the diversity rationale. I think the important point here is that it's absolutely right not to say that there isn't sort of this firm break between diversity and remediation. And you're absolutely right, Kenji, that O'Connor in the Grutter opinion recognized that one of the reasons why diversity is so important is because of the history of discrimination, because we still live in a society where you have persistent racial separation and K-12 education and in housing and so forth. That is a direct legacy of historical discrimination and ongoing discrimination, unfortunately. And so the notion that colleges and universities are an incredibly important place where folks from these different backgrounds can come together and literally learn to live and work with each other is just a vital enterprise.
Host with CQ Press. Since we're almost in October, I have a baseball question. Namely, is Chief Justice Roberts the new cleanup hitter on the court? Has Kennedy goes down in the batting lineup, and is Scalia way down?
I'll say my own view is not so much. I think that it's true in some ways last term's decision did mark the emergence in some ways of a Roberts court, because that decision will, in the healthcare cases, will be studied for so long and will be such an important signature of the Roberts court. And for years it had been called the Kennedy court because Kennedy was the swing justice. But my own view is I don't think things have changed radically on the ground in terms of who the swing justice is. I think that's still Justice Kennedy, as evidenced by some of the statistics that Lisa cited earlier. Do any of you think that Chief Justice Roberts is more a vote in play in some of these high-profile cases?
Not on these, but I just, Adam, you said this twice, so now I'm going to dissent. What is there to study about the healthcare case?
I'm still trying to make sense of the taxing power.
I guess you're a law professor, but the Commerce Clause was all interesting and somewhat academic, and the tax analysis was non-existent. So what are you going to teach?
It will be a challenge, no doubt.
It's the Thomas dissent, right?
Perhaps.
There's some good stuff in the beginning of the, it's sort of an explanation of constitutional law in Chief Justice Roberts' opinion.
It just seems like Bush versus Gore to me. So I don't know, are you teaching Bush versus Gore in your classes?
I do.
Okay, then. The chief is obviously important, but on things like gay rights, on I would say abortion, race, and gays, Kennedy matters.
So you're right. I still think that that Kennedy is going to be the swing vote. Certainly in the same-sex marriage cases, he's regarded to be the swing vote. Ted Olson and David Boies, who brought the...
Unless gay marriage can be reconstrued as a tax, in
right,
which case...
Exactly. But Olson and Boies, quip about this. They're the ones who brought together so they were on opposite sides of Bush versus Gore, but they came together in this kind of bipartisan love fest for same-sex marriage, and so they're representing the plaintiffs in the Perry versus Brown case. Now, I guess, retitled Hollingsworth versus Perry. But they quip that Boies will bring to the table all of the justices who were on his side in Bush versus Gore, and that Olson will be responsible for bringing his justices to the table on the same-sex marriage issue. Obviously, Boies is a much easier task. But Olson repeatedly says, I can count to 5, I can count to 5. So he says that the cardinal rule of any Supreme Court litigator is that you can count to 5, right? And so when you think about which 5 he's counting, I think it's 4 liberal justices and Justice Kennedy. I don't think that he's thinking about Roberts in this way. If I can dissent, Lisa, to your dissent with respect to what is there to teach in healthcare decisions, I'm actually with Adam, which is to say that I think that there's some sleeper hits in that opinion insofar as we have both the Commerce Clause analysis and the Spending Clause analysis, particularly the Spending Clause analysis with respect to what the Supreme Court...
Spending Clause, yeah. I'm talking about the individual mandate. Yeah, the Medicaid decision's fascinating.
Yeah,
Spending Clause.
But I heard Adam to be speaking about the opinion as a whole rather than about any particular part of it. So, and I think what's significant about it is that it seems like...
Ask 100 people if they've heard of the Medicaid holding.
Although it's pretty...
The answer will be 0.
But the thing is, Lisa, it doesn't really matter whether or not people have heard about it. It matters whether or not the states, whether or not the Congress is going to have this power, right? And I really do think that this is the kind of sleeper issue of
I agree. I just think the individual mandate, the signature piece of legislation comes down to a decision that I wouldn't teach in a law school class. That was my only point. Okay, but you're a professor, I'm not.
Right.
I'm sure Kenji and I will both be teaching it in our class. No doubt about it.
I'm not gonna
although you raise interesting points about the significance of the decision in terms of its doctrinal impact. But before getting too much into last term, I want to keep focused on the present term. Other additional questions? If there are no other press
There's a
questions.
hand over there.
Well, I don't think there's any other press questions, so let's open up the floor more generally.
Thank you. I'm Henry Green. I'm a Superior Court judge. This may be off the reservation. It's probably to Mr. Goldstein. In Williamsby, Illinois, which was the most recent Crawford case on the Confrontation Clause, it really leaves criminal litigators and judges who try criminal cases in a quandary as to what we do. I love Justice Kagan's dissent because she says just ignore us in this case. But do you have any thoughts on that? And is there anything on the docket this term? Any new confrontation clauses on the docket, if you know?
So to set the table very briefly, this is one of a long series of cases over the past 5 years or so where the Supreme Court has reinvigorated the confrontation clause when it comes to evidence being admitted in the case without a witness really to back it up. And this happens a lot with reports, though, the DNA matches, or this person took a breathalyzer and they had a blood alcohol level that was too high. And the last term, the Supreme Court got to one of these cases, and the war between the pragmatists on the Supreme Court that just want the system to work and the idealists on the Supreme Court who say, look, even if the confrontation clause is a little bit unworkable, it's nonetheless there, and we're going to have to follow it, kind of became insurmountable in the Supreme Court. And so there isn't the Supreme Court allows an expert to come in and testify even if they weren't the person who actually administered the test. The expert is allowed to discuss what the test results were, so long as the expert says, well, there was these test results. I'm not promising you that the test results are true, but nonetheless, I'm going to rely on them. And the Supreme Court, unfortunately, in a fragmented opinion, doesn't have one rationale for whether that's okay or not. And while the difficulty that's being described by the judge is that although there was a sea change in confrontation clause law, and that may have been difficult for some prosecutors and for some trial judges, at least people knew the direction that the law was going in, and they were starting to, okay, we'll take the confrontation clause very seriously. And the Supreme Court, as was mentioned, and Justice Kagan has this dissent that says, you look at our opinion today and we don't know what we're telling you to do. And so we are in a very difficult interregnum over the next couple of years on the confrontation clause. There are dozens of cases on their way, but there is not something on the table now that would allow them to make clear what we will do in this situation where you have a test result and the government's going to bring in, a prosecution's going to bring in an expert who's going to rely on the test result and exactly how that system should work. This is a very significant mess that the Supreme Court has created, and there is no imminent way out, unfortunately.
I don't know whether to say thank you or not.
I'm Bert Wides, a pro bono private attorney, and I wanted to ask Professor Winkler a question about your comments regarding the extraterritorial issue of the Alien Tort Claims Act. You said you thought the court, I assume you meant the conservatives, didn't want to decide it on the corporate issue, and I'm wondering if you thought that was primarily because of their aversion to U.S. courts' intrusion abroad, or as a way to protect corporations because they would obviously be protected by a non-extraterritoriality decision, but doing so in a way to avoid the image of the pro-corporate court after Citizens United.
I think that was more to me than to Adam, but yeah, I think more the latter. I mean, they have this very legitimate four-square opportunity to say that there's no extraterritorial application, which I think would be certainly the position I support, and that does give them an out from not having to decide an issue that would be more politically contentious, which at least Roberts, who is likely to be the assigning justice in this case, I think, certainly cares about.
Hi, Jeremy Scott from the Electronic Privacy Information Center. I was just wondering if anyone on the panel had any thoughts about Clapper v. Amnesty and the standing issue raised there.
Any thoughts?
It's a really technical standing case. I know the interesting parts. There's lots of interesting atmospherics about it. I think it's more likely than not the court will reverse the Second Circuit's grant of standing. Just to explain a little bit about what this case is, a number of journalists, academics, and others are contending that the warrantless wiretapping of foreign communications intrudes on their rights to communicate with certain journalistic sources or people that they work with in the Middle East and other places where there might be people who are under surveillance or whose communications might be surveilled under, again, this foreign wiretapping program. They're sort of, collateral they're American collateral damage to this foreign wiretapping, but they don't know, because of course it's a secret program. They don't know who that they communicate with might be under surveillance, or whether any of their communications are. They say that their speech is being chilled, and the issue is, do they have standing even to raise these concerns about the larger constitutionality of the foreign warrantless wiretapping? I think the court is very likely to, and not by a 5-4 margin, probably unanimously or close to it, say that the harms that they allege are too speculative under existing standing law to give them that standing.
We are at the end of our allotted time, so I want to thank Tom Goldstein, Lisa Blatt, Kenji Yoshino, Elise Boddie, Ilya Shapiro, and the American Constitution Society for putting together this terrific panel.